SJC 12920, Saeed S. Abuzara, v. City of Cambridge.
Good morning, Counsel. Mr. Leonard, please.
Yes, good morning, Your Honor. May it please the court. This case is an eminent domain case that I'd like to discuss two issues with the court. The first issue is whether the plaintiff in an eminent domain case can accept a pro tanto award and then simultaneously assert and prosecute a claim that the eminent domain taking is invalid. The second part of that I'd like to discuss is the public policy reasons why the court should not allow that tactic to be used. The basic facts of the case are simple. The case arises out of an October 7, 2016 eminent domain taking of the plaintiff's property, which consisted of a 28,000 square foot parcel that had several abandoned apartment buildings on it. The city made the taking for the purpose of the creation of affordable senior and transitional housing and for other municipal purposes. The pro tanto was awarded to the plaintiff in the amount of $3,700,000. At the time of the recording of the order of taking, there was a case pending in the Middlesex Superior Court entitled ABER, A-B-E-E-R, Inc. versus Success Realty Trust, where the title to this property was put into question. That case had been filed in January 21, 2013, some 3 years before this taking, but little action had taken place on the case. Pursuant to General Laws, Chapter 79, Section D, the plaintiff was under a legal disability, therefore, because he couldn't prove title to the property, and therefore the City of Cambridge deposited the $3,700,000 pro tanto with the city treasurer until this issue was resolved.
Hey, Leonard, can I just stop you there? Because understanding the facts of the case, my question is, where did the single justice go wrong, and what standard of review should we be using?
Yes, the single justice, Your Honor, went wrong for several reasons. First reason is he really didn't accord the considerable deference to the learned opinion of Judge Henry in the Superior Court. He really even addresses the rationale behind Judge Henry's determination. And the error in the single justice ways is he makes a determination at the outset of his opinion that this issue is controlled by an interpretation of the statute. And he says that the statute admits no exception on its face regarding making takings and then having a challenge of the taking. It doesn't deal with the issue he rules, and therefore he applies the statute literally and determines that the money should be paid over to Mr. Abuzara. The single justice actually cites General Laws, Chapter 79, Section 3, which says that the right to damage vest on the recording of the order of taking unless otherwise provided by law. The single justice gives no application whatsoever to that exception to the payment of the pro tanto unless otherwise provided by law. He applies the general rules of construction of statutes when, in fact, the evidence indicates that this statute is part of the general rules of payment of eminent domain damages contained in Chapter 79, Section 7, A, B, C, D, E. They're a set of mechanical statutes. They're procedural statutes. They don't deal with the substantive law, and the judge applies those statutes as if they did apply to substantive law. This particular eminent domain statute does not contemplate a situation where the validity of the taking is raised. It doesn't even portend to deal with that issue. And the important error that the court
doesn't the single justice's order track the statutory language that the pro tanto should be paid when the taking is recorded, right? it does track it, right?
It
I
does-
understand you have policy reasons, but and there isn't an otherwise provided by law, right? There's no statutory exception that meets
Well,
this.
I'd respectfully suggest to the contrary, Your Honor, and that is General Laws, Chapter 79, Section 3. It says that the eminent domain pro tanto should be paid over unless otherwise provided by law. And in point of fact, we have cases in Massachusetts which suggest that it shouldn't be paid over, but they're not as precise as the cases from other jurisdictions that I cite. More importantly, I think, Your Honor, is this court has said when you're dealing with a case of statutory silence.
Can I raise a hypothetical for you? I understand it's different than the one we've got here, but
Sure.
say this is the person's house. This is, this is not a business person, but Cambridge has taken somebody's home. That home, maybe even a home where they rent it out because they need help to pay their mortgage. Cambridge takes the house, then the person thinks that taking is improper, but you've taken both their home and their means of livelihood, so they don't get the pro tanto award? How do they live?
Well, they have an election to make, Your Honor. First of all, if they are going to challenge the validity of the taking, then they should not accept the pro tanto award. The general rule is the pro tanto award is placed with the clerk until the validity of the taking is determined.
How are they going to litigate the validity of the taking?
They're going to
They don't
litigate.
have any they don't have any money. They don't have a home, and they don't have a pro tanto award. How do they litigate the validity of the taking?
They litigate it because they could bring an action in the Superior Court to restrain further action regarding the taking until a validity question under those very unique circumstances has been determined. And that would be appropriate for the Superior Court to grant that type of relief under those circumstances. As Your Honor knows, and I won't get into the technicalities of it, but where you're dealing with a residential taking, there are state and federal relocation regulations which strictly govern that type of matter. You have 4 months before you have to leave the residence as a matter of law. And also the state and federal regulations require all kinds of payments for relocation, finding another location, affirmatively finding a location that's reasonably comparable to the property taken. Here, the error in the single justice.
But how do they don't get the pro tanto award? They can't buy that property, right? They've got no money, and they don't have the money to hire Mr. Bowen.
Few people do, Your Honor, but I think in truth, it's the discretion of the Superior Court to give injunctive relief to prevent that type of awful circumstance from happening.
Counsel, you said a few moments ago in an answer to Justice Lowy's question that the general rule is that the money goes into the court to be held in escrow. Is that, when you say the general rule, where does that come from?
Well, it comes from a combination of statutes, but in this particular instance, it was the discretionary judgment of Judge Henry.
Right, but I'm just looking for the sources. So you're saying it's a combination of statutes to get to this general rule. I understand Judge Henry's decision. So
Yeah, the combination of statutes would be 7B, 79, Section 7B, C, D, which talk about the payment of the pro tanto award.
and it says to put it in escrow if there's a dispute.
Well, that's certainly the inference, and that's the common practice of most Superior Court judges.
Mr. Leonard, I'm looking at some of the appeals court decisions, and they make clear that they're certainly separate civil actions. There's no codependency, correct?
Yes, I think that's true, Your Honor.
Okay, and then what happens practically if the plaintiff homeowner loses and the taking is lawful?
If the taking is lawful, then the homeowner would receive the pro tanto award.
Right,
Plus
what happens when the
plus
plaintiff, what happens the other way when the plaintiff wins?
If
The
the
take-
plaintiff, if the plaintiff wins, then the burden would be on the city to accept the property back and to compensate the plaintiff for any damages that has accrued to the plaintiff from the date of the recording of the taking until the date of the judgment of the Superior Court or a final judgment of the Appeals Court of the Supreme Judicial Court, including attorney's fees.
And that compensation would take care of whatever monies was spent off the pro tanto award to defend, right, or litigate.
Yes. Well, no, it would be in addition to the pro tanto award.
In addition, right?
Yes, in addition. But I'm trying to suggest here that
I'm just trying to ask you the practical realities of having this money either go or stay.
well, the practical realities are very, very difficult, Your Honor, because as you know, anytime that property is taken by eminent domain by a municipality for a wide variety of reasons, including affordable housing or including expansion of municipal hospitals or the establishment of facilities for people who are drug addicted and all of that. These are not popular takings with abutting properties. And one of the issues that the court has to confront in these situations is what is the proper way to give people the opportunity of challenging the validity of the taking if it is a bona fide challenge to the taking, but as opposed to somebody bringing a claim to invalidate a taking in order to tie up the property for 40B purposes for extended periods of time, hoping that the municipality will not go forward with the taking.
I'm sorry, please continue.
In this particular instance, Judge, the plaintiff accepted the pro tanto, I believe in late November, early December of 2019, and the city, what happens when somebody brings a challenge to the validity of a taking, there's a cloud on the title, Your Honor. And as a result of that, the municipality isn't able to finance the public work for which the property was taken. So in this case, while the dwellings, the two apartment houses that were on the property were demolished under supervision of the Superior Court judge, this property has laid fallow for 4 years and 2 months and probably will remain the same for the next 3 or 4 years just because somebody has brought a challenge to the taking. And so that is one of the real burdens that the municipality experiences under these circumstances. And it's not just not having the opportunity to utilize and develop the property for a legitimate public purpose. We also have construction and redevelopment costs.
But whatever the practical realities are, as Justice Kafker asked you, we're governed by the statutes, correct?
Yes, you are, Your Honor. And here, I'm suggesting to the court that where you have a statute that is silent on the issue of validity of the taking, the regular rules, the regular maxims that one applies is not the same. This court has taught that in cases of statutory silence, the court does not employ conventional or statutory constructions in a mechanical way that upends the common law and fundamentally makes no sense. And
So are you saying, Mr. Leonard, your position is that opinion of the justices and the common law would be, unless otherwise provided by law, and that pro tanto is basically the functional equivalent of damages?
It's a functional equivalent of temporary damages, allowing the landowner to petition the Superior Court for additional damages. In this case, where the single justice didn't apply the standards that this court has set forth in a statutory silence sense, he made a finding, this single justice made a finding that the cases that we cite in our memorandum, which he said are old and out of state cases, are inapposite. I have to confess to the court that I actually had to look up what inapposite meant. And it
Not
means,
good for you. It's not good for you.
well, well, I'll tell you what it means. It is good for me in this sense. It means irrelevant. This single
Yes,
justice said that all of the cases cited by the city of Cambridge in its papers are irrelevant. At the same time, this court has cautioned in statutory silence cases that you have to be very careful in not upending the common law. And the judge says the common law is irrelevant under these circumstances, and it's not irrelevant under these circumstances.
Can I ask you, Mr. Leonard, which cases do you think are the most important for you for the out-of-state cases? In terms of the out-of-state cases, I'm not familiar with the statutory scheme in other states. Could you tell me which states have comparable statutory schemes and deal with this in some fashion that you think is supportive of you?
Well, I think they all do, Your Honor. I think all of the, in fact, it's just the opposite of that. In our memorandum, we cite 11 cases from 10 different jurisdictions, including an opinion of the Supreme Court of the United States, all of which support the position unanimously that one cannot challenge the efficacy of validity of the eminent domain taking if you accept the pro tanto award. And in point of fact, neither Mr. Bowen, my colleague and friend, who has been trying eminent domain cases with me for 30 years plus, he can't cite one case, nor does the single justice cite any case in support of the proposition that you can challenge the validity of a taking and accept the pro tanto award at the same time. There's no authority for that position whatsoever. The Bible on eminent domain, Nichols on eminent domain, says you can't do it. CJS says you can't do it. Amjur says you can't do it. The model eminent domain code says you can't do it. I admit that's not law in Massachusetts, the model eminent domain code, but there's absolutely no authority whatsoever for this novel interpretation of the single justice by his applying the statute in a rigid way, ignoring common law. If the justice had paid attention to the common law, he would have understood that these various jurisdictions, some going back, the Supreme Court case goes back to 1908, and the latest case that we cite is 1990. So from 1908 to 1990, there's no case in the United States that supports the plaintiff's position.
But there's no case that supports your position directly either. There are gaps in all of these cases, right? Nothing's right on point here. You're relying on these old equity cases that are distinguishable. We don't have the exact factual scenario here in any of these cases.
No, you never do, Your Honor. But if you read the 11 cases and the cases that are certainly more current, the cases after the rules of civil procedure have been updated so that you can bring in simultaneous contradictory theories in the case itself, but you can't accept a judgment or you can't accept money.
But this isn't a final judgment. This is a pro tanto award. It's not a final judgment. I understand you can't win the case and then try to have it both ways, but this is a pro tanto. It's an interim solution. It's not a final judgment.
No, but what happens, Your Honor, if you want to look at the big picture, and you know that 40B types of takings, and more often than not, and practically speaking, are not embraced by neighbors and surrounding properties. What happens if, in order to delay the project 5, 6, or 8 years, just by bringing a claim that the subject property has been targeted, that some of the procedures haven't been followed. Your Honor, when you read Chapter 79, Section 7, B, C, D, E, you also read Section 10A, which says that if there were imperfections in the way that the pro tanto was handled, none of those imperfections, while they may accrue damages for the plaintiff in the case, none of them are adequate to defeat the validity of the taking. So these are really procedural statutes we're talking about on 79 B, C, and D. And as a matter of fact, most of the cases that we cite, admittedly out of state cases, but dealing with jurisdictions like Maryland and in California and in Texas and in New Jersey, they all deal with essentially the same fact pattern, where somebody is seeking to challenge the validity of a taking while accepting the pro tanto, and the general rule is that it is not permissible to do so because it's unfair to the taking authority, and it's electing remedies and then seeking to continue to secure additional damages. Here, the city never was hiding the pro tanto from the plaintiff. We always wanted to pay the plaintiff the pro tanto, but only if, as and when, the plaintiff acknowledged that he couldn't pursue the invalidity claim.
Well, wait, that's not in the statute though, right? That you get to withhold that if he waives further rights.
The common law provides that you're not able to challenge the validity of the taking and accept the pro tanto at the same time. That's the prevailing common law in every state in the union, and it's that way for good purpose. Certainly, the plaintiff can accept the pro tanto and continue to litigate to secure additional damages. That's what the pro tanto statutes are all about. And
Can I ask you something along those lines?
yes, sir.
In this particular case, how much more would the owner get? It was what, 3.7 million?
Yes, Your Honor, that's right.
So what percentage of the actual damages is that? It seems like a lot of money.
It is a lot of money, and that was as a result of an appraisal by a licensed appraiser who possesses the MAI degree and a member of the, he possesses a CLE degree. In my experience, Judge, if the city determined that that property is worth $3.7 million as of the date of the taking, in all probability, and in just on the experience of my practice, everyone will come in, a plaintiff will come in for twice that pro tanto or 3 times the pro tanto award. And it just seems to be common form, looking for splits between the appraisers and to secure additional money. But whatever it is, that's the plaintiff.
Let me ask if there are further questions of Mr. Leonard. Thank you, Mr. Leonard. You got us after we've had our coffee.
Well, it's refreshing. Thank you, Your Honor. It's been a pleasure.
I'll turn to Mr. Bowen.
Good morning, Your Honors. Thank you very much. First of all, if I can respond directly to Justice Budd's first question about the standard of review. Justice Rubin followed it exactly and even quoted Jetline Services, which was clear error of law or abuse of discretion. And under Aspinall, which is at 442 Mass 381, page 390, the standard of review in this case was Justice Rubin's ruling legally correct, including whether discretion was abused. And under Aspinall, of course, this court should look at Judge Henry's ruling, which, as Justice Rubin pointed out, contains not a single case citation, not a single reference to the statute that governs, not any reference to treaties. Instead, Judge Henry says that it seems to him incongruous, and then went on to add that it seems to him somehow unfair for Professor Abazara and his family to get a pro tanto because somehow that would be money he's not entitled to. Well, that is completely contrary to the statute. It was a legally incorrect ruling. Justice Rubin, in contrast, went in detail through the entire, pretty much the entire scheme under Chapter 79 and pointed out how, Mr. Leonard agreed that the statute does control, that there's no doubt that the pro tanto payment has to be made in 7B, and it has to be made immediately. The statute says shall several times. In Section 7B, it says pay it immediately at least twice. Prompt appears at least twice. Justice Rubin also cited two very important cases, one Moore versus Sanford and Parr Angel. And Moore, which is an old case, but it's still good law. Moore says, I have it here somewhere, that it would certainly be unjust if a party who reasonably deemed that by statute his property was taken unconstitutionally should somehow be compelled to elect whether he pursues that claim or does exactly what Attorney Leonard wants my client to do, give up that challenge.
But isn't it tougher? I mean, it's a tougher case than Moore, because the only issue here is whether the pro tanto goes into the court or it goes to your client, right? That's the tricky issue, and that's not addressed by any of these cases, right? I mean,
no, I think that's correct, Your Honor. I think the answer really is, as Justice Rubin said, is controlled by statute, and the statute, as Justice Rubin pointed out, has no exceptions.
How do we know that the statute is meant to cover this situation? There's nothing here that talks about if the owner wants to challenge the validity of the taking. So how do we know that it applies here?
The one place where it does get mentioned implicitly and directly is in Section 18, Your Honor, which gives special recognition to the fact that there are validity challenges and that there's an actual extra built-in statute of limitations period for a property owner has an extra 3 months after a ruling to challenge it, or I might have that reversed. I apologize if I do, but Section 18 of Chapter 79 expressly references the right to bring a claim to challenge the validity of a taking. That obviously is the same statute, contains all those mandatory provisions that the entity that takes the property has to pay. And Attorney Leonard talks about the injustice to the city of being held up on a project. That's a potential hypothetical future scenario. Maybe in this case, there's some funding problems. I wouldn't be surprised. But what we have in this case is an actual clear and present and continuing hardship to the owner that is exercising its constitutional right to challenge the validity of the taking at the same time as challenging the taking itself. And all the cases that have been cited, including Parr Angel, as one of the justices pointed out, they talk about a waiver occurring with an acceptance of a final judgment. So implicit and built into the statute, into all the cases, is the right to bring both claims at once, which nobody challenges, and the idea that the pro tanto might require a refund is directly addressed in Section 8A. That if we go forward and we succeed in getting the property back, we have our claim under count 4, as Attorney Leonard recognized, to see how much the city owes us for having taken the property for now 4.5 years and counting. They owe us money for that if we get the property back. If there is what's called a refund judgment, and I've experienced a couple of these when I was at the Attorney General's office, if we get a refund judgment, we would be ordered to pay back the difference between what the pro tanto is and with interest on that, and the city gets their money.
Well, what about the concern of the taxpayers, though? Let's say that the pro tanto award goes to the landowner, and the validity challenge fails.
Yes.
And you have, as often happens with these situations, that you have a drop in real estate value. It's the taxpayers who are out the money if the money can't be refunded by the landowner.
Taxpayers could potentially be out of some money. Justice Rubin addresses that as the risk is on the city that has, Your Honor, all the power here. It was not Professor Abuzar's desire to have his property taken. The city made that taking, and the city now has the property and the money. Now, the city would be required to resort to the numerous legal vehicles for securing a judgment if there was a refund judgment that Professor Abuzar could not pay. First
But
thing
no
that would
one's
happen.
saying that the city should have the money. The issue is whether the money should go to the court or to the landowner. No one's saying that the city should just sit on this money during the validity challenge.
Well, if the money is as a practical matter in real life, if the money is sitting in the court, that's the same thing for now and until, Attorney Leonard said 3 to 4 to 5 years more before this is resolved. That would be a very bad outcome. We've been waiting for 4 years already. But that means the client has been deprived of this money and has no access to it. And we know from the Bromfield case, Your Honor, which I cite in my brief, that this court said in Bromfield that citizens don't have to just sit around indefinitely and wait for their money. We actually have a right to pursue this. And Bromfield even says they left it with, if something wasn't done, it was a state taking in that case, then the court would consider ordering the return of the property. This is a established law of this court, of this jurisdiction. So we can't, right now, he doesn't have access to any of that money. It's all in the hands. I mean, we have it now, but we're keeping it in a safe place because this court ordered, or the lower court ordered it to be returned.
Can I ask you a question, please, Mr. Bowen?
Certainly.
Mr. Bowen, I was asking about the question whether or not there are statutes in other states that are similar to ours, or whether there are statutes that are not so silent on the subject, or whether there is case law that actually supports your position. Has there been any case that really has addressed this and come out your way?
I don't think there's been a case exactly on all fours with this.
So we'd be
I
the
think
first.
that-
You're asking us to be the first, in other words.
I think it would. I think, and in that regard, Your Honor, I think a lot of the cases that Attorney Leonard relied on are cases that were decided before 1974, which, as Your Honor knows, was when equity and law proceedings merged in one action.
And that makes a
And
difference
reason-
because why? Why does that make a difference?
Because some of the cases say that you cannot challenge, back then when we had bills in equity and petitions for damages as a
Yeah.
law action, back then in a petition for damages in a law action, the person bringing that claim was presumed to accept for purposes of that action that the taking was legal, and they could simultaneously say in a separate equity action that the taking was invalid. And that's where some of this confusion comes in. An opinion of the justices kind of miscites this. And that opinion of justices, first of all, was not a case in controversy. It was responding to a legislative question. But second, it was decided in 1971 before the merger. And the sentence that Mr. Leonard relies on so heavily, really, because it cites Barnes and it cites Parr v. Angel and it cites Chapter 79, Section 39. What that means is in that action, when you're looking for damages, you do accept for purposes of that case, but you can, in a separate simultaneous action, say the take was invalid. Now you can do both in the same case. But the specific answer to your question, Your Honor, is no, there's not been one that addressed what happens to the pro tanto. But that, as Justice Rubin said, has been addressed incredibly clearly in the statute. And the
Well,
statute.
I know, we're not as clear about it as maybe as you think we are. I think
Well,
the
it
statute is not
says
as clear.
shall.
It's usually more silence than it is clarity, isn't it?
No, I think it says the pro tanto payment shall be paid. And if there's an overpayment, and this has happened in cases where there's no challenge to the validity of the taking. I've had a couple of those myself at the AG's office. And at the end of the trial, the jury comes back and says the pro tanto was too much. And
Yeah,
then a
well,
refund
that's a different
judgment
story, right? I
entered.
mean, you're talking about one is an argument about the amount of the money that's fair to pay, and the other is whether or not that should be taken at all, whether there should be any money awarded at all, because if it's not an illegal taking, it shouldn't be happening at all, right? So there shouldn't be any
Well,
compensation for the damages.
It shouldn't have happened, but it did. And as Attorney Leonard admitted, under count 4, if we get the property back, we still get damages from the date of taking back in August of
That's right.
2016 until October 2016, until we get the property back. So
That's
we
right.
will get money at some
The
point.
damages, the damages are not the same, quite the same thing, right? Damages for an illegal taking are not the same thing as damages for a legal taking, are they?
Well, yes, they are. The damages
They
for, if the taking is held to be illegal, the taking still took place, and they've still had our property for over 4 years, and they owe us. It's as if they
Right.
took somebody's house for 4 years, and we said, oh, sorry about that. We're wrong, we give it back to you. And then the owner would say, yeah, but I've had no place to live for 4 years. You've had my property. It's like you've rented my property for 4 years. Here's
So the
the
measure
bill.
of damages, excuse me, the measure of damage would be the same, you're saying it'd be the same as challenging it. It wouldn't necessarily be on the pro tanto amount, measure of damages, it'd be the pro tanto amount or whatever it was that was determined to be the right amount of damages for the property itself, right?
Exactly. And it would be prorated because if we win on validity, it's as if they rented it instead of taking it
Yes.
outright.
Okay.
Same way
Mhm.
I could rent a place on the Cape for 4 years, but I don't get it for free because I didn't buy it. I mean, I still owe for the 4 years. It would cost more to buy it, but it would cost a lot to rent it for 4 years too.
Mr. Bowen,
yes,
Mr.
sir.
Bowen, your colleague, your brother cites all the commentators as being on the opposite side of your position, sort of. And, you know, in dirt law, we've got really settled expectations. Will this come as a shock to all those commentators if we decide that you get to keep the pro tanto award and while you challenge the taking? Is there any handling of that in those commentators, Newell and all the other sort of ancient treatises on this?
Well, Nichols, and this was part of the city's briefs from the beginning, Nichols cites a case called US v. McIntosh. There was no Massachusetts cases cited. The short and direct answer, Your Honor, is no, it would be a corrective and they'd have to make note of the fact that there's a difference between law and equity in Massachusetts and many courts until the 70s. But they say that it's about a final judgment. That a pro tanto award.
But this is this goes on across the country all the time. So I'm just trying to get an understanding of, will this be perceived as a radical sort of equity decision by us? Or is this something that's dealt with out there as a, you know, because I'm, you know, again, you know, to me, I understand the equities, not necessarily on the side of your client, but on the side of a, you know, a small homeowner who loses his house and her house and can't do anything. But I'm just trying to get a sense of whether, you know, dirt law is just tough in these circumstances, requiring this choice, and whether we're going to be doing something that's a real outlier if we don't follow that.
No, you will not, Your Honor. And by the way, my client's, you know, kids lived in this place and his sister lived in this place. It was an income producing property, but it was also a place he kept for his family. But no, it would be perhaps a corrective, and it would point out the fact that, you know, there has to be some kind of temporary justice. And there are case law, I can't think of it off the top of my head, where the purpose of a pro tanto, as I believe you pointed out earlier, is to give the owner who's suddenly been deprived completely against his will, his or her, his will, been completely deprived of either an income producing property or a home, and is left what? To do what?
I thought the council, may I interrupt you? I thought the purpose of the pro tanto was to stop the running of the interest for the, against the taker.
There's a dual purpose, and I wish I have 1,000 cases here on my desk. I wish I could put my finger on it.
Okay.
But
so you're saying there's
also,
two purposes.
There are two cases directly on point with that, and one actually addresses that. The first purpose, I think it might be one of the cases that, it's not Cochin 6, I don't think. But,
right.
I apologize for knowing. But
that's okay, but there's another case. It's probably in the briefs, but it's Collins versus Town of Webster. Are you familiar with that one?
Yes,
that would seem to support your argument, wouldn't it?
Yeah, it's a dual purpose. It's to stop the interest running. It saves the taking entity that way, but also it's designed to give the person whose property has been taken at least some money to get, get back on their feet.
Collins versus Town of Webster, also you have the payment of the pro tanto, and you have the homeowners challenging the taking. Is that right?
I think so, Your Honor. I wish I were more familiar with that right
That's
off the top
okay,
of my
because
head.
it just seems that it's a good case for you.
I did, and I like that case then. I did cite a case in my brief, I know, where it says one of the purposes of the pro tanto is to get some money into the hands of the person who, without their asking for it or wanting it, is suddenly left without their property. And, you know, there are remedies. One of them is to let them have access to that money, knowing that there might be a refund judgment down the road, and it's on them. And as far as placing the burden, as Justice Rubin noted, the city has vast amount more access to capital and funding and money. They could raise their parking rates or whatever. My guy is, you know, is a retired professor emeritus from Salem State University. He's got a family that he's been supporting in part off this property. He doesn't have access to this. And he
Mr.
knows
Bowen, can I
full
ask
well-
you another legal question?
Sure.
So there are two types of taking processes, right? There's this
Right.
quick take, and then,
Right.
and then there's the one where you go through the court system. Had they used the other process, right, we wouldn't be here, right?
Exactly, exactly. And I point that out in my brief as well, that we didn't choose either to be taken or the method by which the city chose to take. And the city made a spot taking of a single property. This was not a part of a well thought out highway project or a big, you know, hospital program like Attorney Leonard was referencing. They took a property that's a little more than a half of an acre. They singled out a single property to address what Cambridge calls on its website all over the place, a massive affordable housing problem.
Yeah, I'm trying to avoid the specifics so much as the taking process. Again, I used to know
Chapter
that, right,
88.
it's not familiar, but they can go through a judicial process where you determine the validity of the taking, you establish
Right.
the amount, but instead of that, they went through this quick take where you take the property and then you fight about it. So
Right.
in certain ways, this is a narrower issue, right? We're just dealing with this quick take
Right.
process, right? Yeah.
If they did it pursuant to Chapter 88, the first thing that has to happen, and it happens very quickly, is the person whose property is taken has to say whether or not they're going to challenge the taking. And then that is supposed to be by design resolved right away. And it doesn't go on to damages until the validity or improprieties in the taking has been resolved. So 80A would have been the ideal vehicle for this kind of case, because the city has to know their solicitor in the past has told them that this is a risky thing to take a single property like this. And they could have brought it pursuant to 80A. We would have had this resolved, 3 years ago.
Can I ask just a practical question? Was there not an option for you guys to just sort of figure out, hey, look, why don't you pay us monthly since we're deprived of the property, and we'll go from there. Why do you get the full amount of the pro tanto if you're not going to end up with the property in the end and you have to give it back?
Well, we may have to give it back, Your Honor. I
Well, I'm
think,
saying if you lose. I'm not saying, I'm not prejudging that at all. I'm
right, no, I
saying
understand.
if you ended up losing it, why do you get the whole amount?
Well, the simple answer, Your Honor, is because the statute says we do, and as Justice Rubin pointed out, if we owe money later, that's on us. But that is something that the city needed to contemplate because, as I just mentioned, the city controlled the taking, they controlled how it was taken, and they determined what they thought was a fair amount, which we respectfully disagree with. They didn't ask us what we thought the property was worth. They didn't say, hey, we're about to take your property. We have an appraisal. Do you want to see it? Maybe you can point out problems with it. Maybe you can get your own appraisal, and then we can resolve this before there's even a taking. This was happened boom, without our knowledge. There was a meeting, and then at the meeting, they signed the order issued. This was remarkably fast, quickly done. And we, and I have spoken, I've gone to the city on numerous occasions, said, can't we resolve this? One thing that I pointed out.
Counter to
I'm
the
sorry?
quick taking, how does the quick take statute affect this in terms of there are other ways to do it other than this quick take statute, right?
Yes, there
So
are.
would that have worked with Justice Bud's suggestion?
I think we would have had an answer immediately to the question. If they do it, I think they still have to put a certain amount of money on account in the court. So ADA says that they make a deposit into court of what they think the property is worth. And the first thing we decide is, is the taking valid? We would have, under that scenario, have said, well, if it's valid, we now want them, we might want to withdraw some money, but there are very clear, concrete rules about how that proceeds. But we have an opportunity immediately up front to say, wait a minute, what are you doing? You're acting too fast. And to get back to Justice Budd's question, I've asked the city on numerous occasions, why can't we sit down and try and figure something out? My client has built 40B housing. He's somehow managed to be a full professor of mathematics and also develop property on the side. He's developed 40B housing. He wants to develop 40B housing on this site, or at least affordable housing component. He wants a place for his family, and he wants a place to make a little bit of income on some of the apartments and maybe renting some parking spaces. But he has done affordable housing himself. It's a single small property, and right now, 4+ years later, he's still funding my very modest fee out of his own pocket because he doesn't have any money from the city. He doesn't have rental income from the property that he potentially could have. He doesn't have the ability to come up with development plans or try to imagine the day when he could do something nice with his property, which he has wanted to do for years. Attorney Leonard says they can't make those plans, neither can my guy. He doesn't, and he's sitting there wondering when his money's going to run out to keep this lawsuit going, which Attorney Leonard now says it could go on for like 4 or 5 more years, which is ridiculous. And where's that money going to come from to keep his family fed? He's retired now. He's 88 years old.
Thank you, Mr. Bowen. Any further questions of Mr. Bowen? Great. Thank you, counsel.
Thank you. Thank you, Your Honors.